Welcome back to the Law Stash channel. My name is Anton Vieltsin and I'm a criminal defense attorney in the Southern District of California. In this video, we'll be discussing plea agreements. What to expect in a typical plea agreement in the Southern District of California. And really, this video will apply to most federal courts. Then I'll talk to you about the typical warnings that the court will give you during a change of plea hearing before a magistrate or a district judge. And finally, we'll discuss a case where an individual is arguing that he did not get proper warnings during the change of plea hearing. And we'll see what happens in that case. So let's go ahead and let's discuss plea agreements. In this video, we're discussing plea agreements. In our district, the Southern District of California, our plea agreements tend to be rather lengthy documents. And when I go over the agreement with my client, I read it to my client word by word. We're not going to do that today. Instead, I'm going to cover the general topics that you typically see in a plea agreement. Something for you to keep in mind. The plea agreements are not written by the defense attorneys. They're usually written by the United States Attorney's Office. Of course, we negotiate the plea agreements, but the final document is drafted by the prosecutor. And the second item that you need to understand is that you have a right to go to trial. You do not have to accept the plea agreement as it is. And even if you choose to plead guilty, you can plead without a plea agreement. And there are sometimes advantages to pleading without the agreement versus with one. And in fact, in the case that we're going to discuss later in this video, Mr. Ferguson did not plead guilty with a plea agreement. He pled in front of the court without one. So let's go ahead and first discuss what we typically see in the plea agreement. During the change of plea hearing, the first thing that the judge will probably ask you is whether you had any alcohol or drugs in the last 48 hours. The judge is trying to see whether you understand what's going on in court. She will then talk to you about your level of education and maybe any other mental impairments. Again, the idea is to gauge whether you understand the proceedings as a whole, whether you understand that you're pleading guilty. This is the item that's not going to be in the plea agreement, but changes of plea hearings typically start with this question. The first thing we usually see in the plea agreement is the charge. It will explicitly tell you what you're charged with and what you're pleading guilty to, which violation. Then it will go into the elements of the crime. Every crime in the federal court has elements. These are the type and items that the prosecutor has to prove at trial. If he can't prove all elements of a crime, then you're innocent. You're not guilty of that crime. By pleading guilty, you're admitting to all of those elements. The next thing is going to be the factual basis. In fact, the magistrate judge will ask you whether the facts match the crime. So your attorney or the prosecutor or sometimes the judge herself will read you the facts. Those facts have to match the elements of the crime. And then she'll ask you whether that's true. Of course, if you're pleading guilty, you're accepting responsibility, meaning that you're accepting that what's on that paper is true. If you choose to say that that's not true, really, you should not be in the hearing at all. You should tell your attorney before that hearing that you don't feel comfortable pleading guilty to the crime. The next item we're going to talk about is penalties. Your plea agreement will spell out the maximum, the mandatory minimums. It will spell out the maximum fine, special assessments, and supervised release. Something to remember. These items are found in the statute itself. Usually it has nothing to do with you. We just look at the statute that you're pleading guilty to, and we're looking at those maximums. The judge does not have to follow whatever the statute says. In some cases, we are dealing with mandatory minimums. If the mandatory minimum applies, then the judge cannot give you less than the mandatory minimum, unless exceptions apply. In terms of supervised release, it will also spell out the length of the supervised release and what happens if you violate that supervised release. In case you don't know, supervised release is the period that follows any period of incarceration. So if you receive, let's say, 2 years of prison time, once you're released, you will be supervised. That period is called supervised release. If you violate your supervised release, you can be brought back to court in front of the same judge and sentenced on that violation. My best clients are the ones that don't violate, and I never see them again. But once in a while, you get a client that violates, and that process can become repetitive. The person will come back to court over and over every time they violate conditions of supervised release. The next item that the plea agreement will have is your trial rights, and that you're waiving those rights. Of course, you have a right to go to trial. You have a right to a jury and sometimes a bench trial. You have a right to cross-examine all witnesses. You have a right to testify, or if you choose not to testify, that cannot be used against you at all either. That's called the Fifth Amendment. And of course, you have a right to your attorney to be present at that trial. Those are your trial rights. By pleading guilty, you're giving up your trial rights, meaning you're not going to trial. The next item is going to be whether the plea is made knowingly and voluntarily. That means that it will spell out that all the benefits of the plea agreement. It will warn you about collateral consequences. When we're talking about benefits, we're dealing with right to vote, right to possess firearms, right to hold office. If you have a federal felony, you're probably giving up those valuable benefits. In terms of collateral consequences, if you're on probation or parole or supervised release, this new case that you're pleading guilty to might have a negative impact on that previous case. And finally, if you have any professional licenses, by pleading guilty, you might be giving up or being ineligible to no longer practice your profession. So before my clients plead guilty, we always discuss those items. If you do have a professional license, it is important for you to chat with your attorney whether whatever crime you're pleading guilty to will have an effect on your license. And finally, the plea agreement will spell out that there's no threats and no promises outside the plea agreement. Next, the applicability of the sentencing guidelines. I have a number of videos where I discuss the federal sentencing guidelines. Now, this is the book that's published by the Commission every year, or just about every year, where every crime is listed and the proper punishment for that crime. Now, these guidelines are not mandatory. They're advisory, meaning that the judge has to look at them first, but then it becomes up to the judge what your sentence will be. Whatever is in that book is just a recommendation. The judge can give a sentence that's higher or lower than whatever the guidelines say. And finally, there's going to be a pre-sentence report complete to assist the judge in finding a just punishment. Now, that PSR, or pre-sentence report, is completed after the change of plea hearing. Usually in our district, if you plead guilty, your sentencing hearing is set about 3 months out, roughly. And in that period, a probation officer meets with you and discusses your background, your employment history, medical history, about your family, about your childhood, and so on. Your attorney will be there during the interview to assist you and guide you through the process. Number 9 sort of goes hand in hand with number 8. The sentence is within the sole discretion of the judge. There are no promises by the government, and any estimates by your defense attorney are just estimates. They're not binding on the court. The judge makes the final decision. Typically, in our guidelines, in our plea agreements, you will see the guideline calculation, so you know where your case is going. It will also discuss whether you can argue for downward adjustments or variances. These are items that your attorney will bring up to the sentencing judge to get a lower sentence. Because remember, the guidelines are only advisory, meaning in a typical case, your attorney can do a good job at sentencing and get you lower than whatever the sentencing guidelines say, depending on the judge, depending on the case, and depending whether there's enough mitigating evidence to ask for a lower sentence. Number 12, it will discuss the parties' recommendations. Now, in our district, the Southern District of California, we typically do not see exact recommendation by the prosecutor. Instead, it usually lists what the guidelines will be. Usually, it is whether you're getting a high end, a low end, or somewhere in between the guidelines according to the prosecutor. And most of our plea agreements do not bind the defense on their sentence. Finally, by pleading guilty, there's going to be a section about appeal and collateral attack. You always have a right to later attack your plea based on ineffective assistance of counsel, meaning that your defense attorney didn't do a good job. But sometimes the plea agreements also spell out the levels at which you cannot appeal. And so most plea agreements will have a number, let's say 70 months or 50 months. If you get higher than that, you can appeal. But if you get a lower sentence than whatever is spelled out, you cannot. And some plea agreements just flat out say no appeals. Now, of course, if you're pleading guilty, there's usually not much to appeal. There's only the change of plea hearing and sentencing. And so in the case we're going to discuss in a moment, we're dealing with a change of plea hearing. So if you remember, if you went to trial, there's more items to appeal. The plea agreement will also talk about the breach. What happens if you breach the agreement? Now, something to keep in mind. Plea agreements are just like contracts. If you breach your side of the contract, the other side can still uphold the contract. It doesn't just get ripped up and goes away. What it means is that the government can now recommend more time than, let's say, they were supposed to under the agreement. But it doesn't mean that you're no longer guilty, or it doesn't mean that you no longer pled guilty. Any modifications to the plea agreement will be in writing. There's going to be nothing oral out there, no promises, no rewards. Everything going to be in the plea agreement. By signing this agreement, you will certify that you have read it, or somebody has read it to you in your language. And finally, that you're satisfied with your counsel. These are all the items you will see in a typical plea agreement. Again, if you choose to plead guilty, you don't have to sign the plea agreement. You can plead guilty without a benefit of a plea agreement in front of a judge. But usually there are benefits to pleading with a plea agreement. And finally, of course, you have a right to go to trial. By pleading guilty, that means you're not going to trial. You're accepting responsibility. So let's go ahead and take a look at United States versus Ferguson. This is a Rule 11 objection and appeal to the Ninth Circuit. Mr. Ferguson argues that during a change of plea hearing, the judge is supposed to go over all of these items and make sure that he understands what he's pleading guilty to. In his case, the magistrate judge never asked about alcohol use, level of education, or mental impairment. And that judge never explained or asked Mr. Ferguson whether he's pleading guilty voluntarily. And so we don't know whether he was explained about the threats, about the promises outside the plea agreement, because that question was never asked. Now, he did not make that objection during the change of plea hearing. Instead, he got sentenced according to the plea agreement. In his case, this was a bank robbery case where there was a theft of $132,000. He received an 84-month sentence, which was lower than what the guidelines called for. His guideline sentence would have been 97 to 151 months. So he got a lower sentence. And finally, like I said earlier, he did not plead guilty according to a plea agreement. This was an open plea without a plea agreement. But according to Rule 11, the judge still has to go over some of these items during the change of plea hearing. Of course, some of them will not apply. For example, under the plea agreement, you typically waive your right to appeal. If you're doing an open plea, you're not going to be waiving that right. So in this situation, he says because he didn't receive two of these warnings, that is an error. But because he didn't make a timely objection, the court says they have to review it under the plain error standard, which means first they have to see whether there's an error, 2, whether it's plain, number 3, whether it affected his substantial right, and number 4, whether it affected fairness, integrity, and public reputation of the court. In this case, we're really talking about only the third element here. In order for him to show that his substantial right was affected, he has to show that there's a reasonable probability, but for the error, he would not enter the plea. Now, when he gets to the appellate court, he doesn't show anything in the record that he would have not pled guilty if he was given those 2 warnings. We're looking at the entire record, meaning that the court looked at the pre-sentence report where he seemed apologetic. He told the probation officer that he made a mistake. We also looked at his history and the sentence itself. When we're looking at his history, we see that this is an individual that does not have a substance abuse problem, and he has a somewhat decent level of education. Now, Mr. Ferguson's attorney argues that this affected his substantial right based on the fact that simply the error was done and that he was not given these warnings. And the attorney cites to another case, Fuentes, where the change of plea was set aside simply because those warnings were not given. But the court says that that case is different, because if we looked at the entire record in that case, then we can look at the person's health. That person had PTSD, depression, anxiety, and he had severe substance abuse problem. And if we look at all those factors, it is not clear whether he would plead guilty if all of the warnings were given. And in this situation, the Ninth Circuit says that it looks like he would have pled guilty. And in fact, on appeal, he doesn't argue that he wouldn't. What it comes down to is it sounds like Mr. Ferguson just didn't like his sentence. And so his attorney was trying to figure out all ways possible to appeal. And when you're dealing with appeals, sometimes you look at the record and you try your best to win that appeal. So what did we learn from this video? 1, you now understand what to expect in the plea agreement, how the change of plea hearings are conducted, and finally, the lesson in Ferguson is that hire your attorneys wisely. When you're doing a change of plea hearing, be confident that that's what you want to do. Because often enough, I get calls where it is simply too late, whether they're time barred from appealing or whether the appeal is not going to be that helpful. And so it is important for you to hire somebody good from the outset on your case. And hopefully, by the time you're at sentencing, you're satisfied with the outcome. If you enjoyed this video, please click like, Subscribe, hit that bell notification button so next time I post, you'll be first to know. Thanks for watching.